ask you this. Have you ever hired a contractor to design your logo, build your website, create an app, or develop a piece of software, and then stop to wonder who actually owns the final product? If you don't have the right legal protections in place, your contractor may still own the intellectual property. That means they could potentially repurpose or even resell what they've built for you, including to your competitors, if you're working with contractors to build valuable technology or content. This is something you need to understand, because paying for someone to create your IP does not automatically mean you own it. Hi, I'm Damin Murdock, principal lawyer at Leo Lawyers. You might already know me, or this is your first time visiting our video library, and while this looks and sounds like me, you're actually watching my AI avatar, speaking from a script that I've personally reviewed and approved. Let's start with the basics. The law makes a distinction between IP created by an employee and IP created by a contractor. If an employee creates IP in the course of their work, that IP is generally owned by the employer, although employees still have moral rights and could argue something was created outside of their job description. That's why your employment contracts should always include comprehensive IP clauses that cover new inventions, confidentiality, and non-solicitation. Now let's turn to contractors. Here's where things get interesting. There is no implied law that says IP created by a contractor is owned by the principal. In fact, the opposite is true. By default, the contractor owns the IP. Unless there's a written assignment, there's no transfer of ownership. Sometimes a contractor will grant a license instead of transferring ownership. That license might be implied if you've paid for the work. But the question then becomes, what kind of license do you have? Licenses can be structured in a lot of different ways. You'll hear terms like irrevocable, perpetual, sublicensable, transferable, worldwide, royalty-free, and rights to exploit. For example, sublicensable means you can pass the license on to a subsidiary. Transferable means you can sell your business and transfer the license with it. Worldwide means you can use it anywhere. Exploit should be broadly defined to cover copying, producing, adapting, varying, changing, improving, commercializing, and even reverse engineering. Now, if your contract says you get an irrevocable, perpetual, worldwide, royalty-free, sublicensable, and transferable license to do all those things, that's close to ownership. But here's the catch, it still isn't ownership. The contractor still owns the IP, which means they can turn around and sell it to someone else, maybe even your competitors. They might sell it cheaper than what you paid, which destroys your competitive edge and lowers the barrier for others to enter the market. That's a huge risk. This is why ownership is always the preferred outcome for a principal. But ownership has its own pros and cons. Let's say you want to hire a contractor with experience in your space. They may have an existing code base that can be reused for your project. That can save you time and money and help you get your product to market faster. This is why contracts often break IP into three categories: existing IP, client IP, and project IP. Existing IP is what the contractor has already created before working for you. Client IP is what you already own as the principal. Project IP is what the contractor creates for your project. A good agreement will say that the contractor keeps ownership of their existing IP, but you get a perpetual royalty-free license to use it as part of your project. You keep ownership of your own client IP, and you give the contractor a limited license to use it for the purpose of completing the work. And finally, you, the principal, own the project IP, what the contractor builds for you. Sometimes you may find yourself in a situation where a contractor has already built something for you, but you never secured ownership in writing. Don't panic. You can fix this with an IP assignment deed. This document retrospectively confirms that any IP created by the contractor as part of their engagement is now owned by you. In terms of cost, having a lawyer draft a contractor's agreement with a comprehensive IP license will usually cost between $1,500 and $3,000 plus GST. An IP assignment deed is generally between $500 and $800 plus GST. Here's the takeaway. If you don't own your IP, you don't fully own your business. I'm Damin Murdock, and this is Leo Lawyers. This video contains general information only. If you need expert legal advice, you'll find our contact details below, or visit our website, leolawyers.com.au. See you next video.